always appreciate a short argument. I can be
Okay, but let's not.
Yeah.
But that's three broad issues. Number one, the real issue in a marriage which is broken is maintenance and custody. That's the real issue.
Yes.
Divorce is used, not giving divorce, is used as an instrument to ensure I get the best order on custody and the best order on maintenance. What this court needs to do is to divorce these two issues. These are two separate issues. The core issue in a marriage, if it is not working, is maintenance and custody.
No, there is another issue also in the Indian context. I have dealt with up to number of cases where sometimes I told you the women have gone as far as to say, yes, he is married another, he is a child. Then both women have equal status, but don't take away my status.
No, I'm coming to that. That's a separate issue. What I'm saying is, Malaj, in India, marriage at the inception is a social contract. Once the marriage has taken place, then it becomes a matter of choice. Now, that social contract, as my learned colleague said, involves family, it involves caste.
Many factors.
Many factors. So when you enter into that marriage, Malaj, it's part of that social contract. Now, after 3 years, 4 years, 5 years, you feel I can't live. Now, that's personal autonomy. That's choice. That's can't be wasting my life from 40 to 55. The petition for divorce. Losing my life in the process.
You were not there when Mr. Indra Jaising was there.
I'm just saying.
She said you had a choice, you could have done this when you were the law minister.
So, Manoj, therefore, the point that I'm making is there is an issue of personal autonomy and there's an issue of social contract. And therefore, that power should not be given to the trial court, that power should be exercised by you. Now, the question, how do you exercise that power? What's the procedure? Well, I dare say, to prove cruelty is almost impossible. To prove adultery is almost impossible.
Many cases succeed.
No, but in the context, of course cases succeed, but in the context, it's very, very difficult. It carries on for years.
Exactly.
Therefore, so by the time you come to this court, the marriage is over. And then you will consider it, and the most precious.
What is the solution?
I'm coming
to that level. Because we know that all these cases are wrong. So one of the argument was, when you were not there, that if you are saying there's an irretrievable breakdown of marriage, there has to be fact finding.
Correct. I was coming. I knew, I was coming to that. I had three more minutes, I'll come to that. Now, when you divorce when you segregate divorce from maintenance and custody, then you can file affidavits. Now you come to the procedure before the trial court, the family court, saying this is what has happened, this is how he is adulterous, or this is how he is dealt with me. That response in affidavit will come, and the trial judge can come, family court can come to the conclusion that prima facie, this seems, and the test has to be much lower than the test that is applied normally. Much lower. And if prima facie comes to that conclusion, that matter, the family court can't grant divorce, but it can come to that prima facie finding. That will shorten the entire process of litigation. You can come then to the High Court and come in 142 for you to grant the divorce. So please appreciate that the process is as important as anything else. If the process gets prolonged, 21 is effective. Well, I have a case, and I've done several of them, where there is adultery. We know there is adultery. The father says, have a DNA test. Or the wife says, have a DNA test. He says, I won't have a DNA test. So then what happens? You can prove it. You know it. Where do you go? What do you do?